second panel discussion, we're going to analyze the most important thing here, because we're talking about union, which is made up by different democracies, and there is a conflict. And I'm going to allow myself a privilege, which is when we hear from our two speakers, I will ask them a question. But this is a question I want to ask them, a question that I ask because I have nothing better to do. But I want to ask this question because that is where the proof of the pudding is. So for the second part, for this session, we have two people with us who have two different perspectives, but I do think they converge. On the one hand, Catherine Barnard, our dear Catherine Barnard, she's going to be angry at me, but she has been just appointed the best professor at Cambridge University. Best professor in Cambridge University. Don't be angry at me. So she knows how much I appreciate her, how much Carlos III University appreciates her. And I hope that from now on, the Del Pino Foundation will truly appreciate her after today. And then I have to thank Mr. Alessandro Nucara for being here today. He traveled from Brussels to Madrid to participate in this meeting with a more technical viewpoint on a subject which is very controversial and also very much new, because in the integration process of the EU as a consequence of an institutional decision and therefore a democratic decision, an instrument, a preventive and sanctioning instrument has been developed so that in certain circumstances the European Union can make serious decisions to punish states that perhaps don't understand fully what the rule of law means for the foundations of the integration process. That's all I wanted to say. And once again, thank you very much, Catherine. Barnard, you have the floor.
Indeed, for those immensely kind words. A huge thanks to the Foundation, but in particular to my wonderful friend and colleague, Carlos Morero, for organising this fine event. I would like to talk about two issues connected to the rule of law. The first is about the rule of law itself and how the Court of Justice has sought to uphold it. And secondly, I would then like to look at the risks that might come with the heavy reliance on the Court of Justice in protecting the rule of law. So to start with the establishment of the rule of law itself at EU level, if you look at the Maastricht Treaty, it is quite striking that there are only 8 references to the rule of law. Of course, importantly in the preamble, setting out the values of the European Union, a reference is there. But in fact, what's really striking is that most of the references to the rule of law concern development cooperation. So rule of law was seen as an external issue, not an issue for internally within the member states. And how that has changed. If you just look at the Court of Justice website and you just type in rule of law, there are now 176 pages of judgments and opinions on the rule of law. So you can see it's become a very major issue. Now, as we know, we've already heard, the Court of Justice itself has been very much involved in rule of law cases, and these have taken a number of forms. Firstly, through enforcement proceedings under Article 258, either directly on rule of law issues, the Polish judges' cases have been referred to quite a lot, but also more indirectly questions about, for example, the logging and the deforestation in the Polish forest. So you've got Article 258 references, and then you've got a very large number of Article 267 references, probably well over 40 now on directly on rule of law issues, some from judges in member states where they are trying to use the 267 reference vehicle as a way of underlining the dreadful plight that they experience within their country's legal system. You've then got Article 263 actions, judicial review actions, in particular where Poland and Hungary have challenged the conditionality mechanism, a challenge which was, of course, ultimately unsuccessful, and even one of those rare birds, an action for failure to act. An action for failure to act because of the concern was that the EU was not doing enough under the conditionality mechanism. And all of these have essentially sprung out of the remarkable Portuguese judges case, where the court incredibly creatively linked Article 19.1, second subparagraph, to Article 2, which expressly relates to the rule of law, and Article 47 of the Charter, and that creative knitting together of those provisions lead you to see the court imposing requirements of an independent judiciary. And as Advocate General Bobek put it very powerfully in one of his opinions, given that the whole EU system is underpinned by law, it is a legal creation. Therefore, in order to make sure that you have an effectively functioning legal system, clearly you've got to have a judiciary at the national level which is functioning, and functioning in the best sense of the word in a democracy, i.e. it's got to have independent judges. So having mapped out very briefly that range of ways that the Court of Justice is involved, I think we should be positive to start with and to praise the Court for its careful articulation of the meaning of the rule of law, and frankly its bravery in standing up to increasingly authoritarian regimes. And I think, as Lauren Peck and Dmitry Kochanov have noted, what we see now is no longer the rule of law just being a rather nice aspirational frilly bit at the start of the treaty, but is now a fundamental principle which is legally enforceable. And I think it's striking that the court has felt able to be so interventionist in respect of the rule of law. And in this way, it reminds me of what was happening in the 1970s, when the court intervened, when the EU legislature was failing in its task to create a single market. And we know the reason for that failure, largely due to unanimity in voting requirements. Once again, in the 1970s, the court had decisions like Cassis de Dijon, which shook up the creation of the single market. Come the 2000s, you have the Court of Justice intervening because the legislature cannot get the Article 7 mechanism to function. This is the modern equivalent of the reshaping of the EU legal system. I also think it's positive that you see the court engaging, as far as it can, in a dialogue, both vertically with the national judiciary, where that is possible, but also horizontally with the European Court of Human Rights. And this dialogue is one that academics have spent a lot of time talking about, but has not always taken place, or occasionally where it has taken place, as with the Bundesverfassungsgericht decision in PSPP, it has been a shouting match rather than a dialogue. So all of this is extremely positive. But there are buts, and there are two buts that I would like to talk about. The first but is obvious and I think uncontroversial. namely that the court is constrained by the cases that are brought before it. It is not an independent actor from that point of view. Of course, in the case of 267 references, it has no idea what is going to be coming through its door. It is worthwhile for a moment just contemplating the following thought experiment. If there had been no cases, and thus nothing for the Court of Justice to decide, what would have happened about the rule of law? And given that I've been very positive about what the Court of Justice has said about the rule of law, I think the answer is pretty disastrous. But of course, the court is dependent on the cases that come before it. However, my second point is less obvious, but I think important. The court we have relied on so much for articulating what is meant by the rule of law, and in so doing has put itself front and centre of the debate. And I think that's a rather dangerous place for the courts to be. Courts are not democratically elected, and thus to some they are the least legitimate branch of the three branches of governments. Moreover, they are also easy targets for the right-wing press. I've seen this in the United Kingdom. You might have heard of two famous decisions, one called Miller 1 and Miller 2, and these were cases essentially about the Brexit drama that was unfolding in the United Kingdom. Now, in respect of Miller 1, this was a case where Theresa May, then Prime Minister, said that she had the power herself to start the Article 50 process. Gina Miller, a very brave, but also rich, for her point of view, that's good, woman, brought a case to challenge the decision of the Prime Minister. And the case went all the way up to the Supreme Court, which said, no, Theresa May as Prime Minister did not have the power to trigger Article 50. There needed to be an Act of Parliament. The reason I mention this case is because at first instance, at the first level that the case was heard, there was the first instance court said, no, there needs to be an Act of Parliament. But the Daily Mail, one of our most read newspapers, had on its front page the picture of three judges, the three judges who decided the case, and underneath it said in capital letters, enemies of the people. And you can see, if you look, it's probably way too small for people at the back to see, but if you can just see it on my iPad there, you can see I'm not making it up. It's on Wikipedia if you would like to see further. But the three judges, all the faces appear, they're all named. And indeed, if you look at the Daily Mail online, it was even worse because they said one is a gay ex-Olympic fencer. It's not clear what was worse, whether he was gay or whether he was an ex-Olympic fencer. But either way, it was extremely personal and completely irrelevant to the fact that these judges, the Daily Mail said, fury over out-of-touch judges who defied the will of Brexit voters and could trigger a constitutional crisis. In other words, they were saying that the judges were blocking Brexit. Now, it had nothing to do with blocking Brexit. It was essentially a procedural, but also a fundamental democratic question. And in Miller 2, I won't go into the details because it's more complicated, but essentially Miller 2 stopped Boris Johnson, who then became Prime Minister, from proroguing, suspending Parliament for 5 weeks at the height of the Brexit crisis. And again, some of the right-wing press responded very badly to the decision of the Supreme Court. Now, at a superficial level, you could say what we saw in the Miller 1 and Miller 2 cases was the Constitution working as it should, with the relevant checks and balances in place. In fact, it took a very brave and wealthy woman to bring a case in the first place to challenge the illegal conduct of the executive. And the fact it took an individual who had real courage to bring this case, or these cases, and a very good legal team who won them on her behalf, shows just the weakness of the British constitutional model. And again, if you ask the question, what would have happened if there had been no Gina Miller? What happens if there had been no one brave enough to challenge this illegal executive conduct? And it may well have dragged the monarchy into the Queen might have had to intervene, which would have been extremely dangerous for our very delicate and, as we've seen, rather fragile constitutional monarchy. Now, why do I tell you all of this? What's it got to do with the question of the rule of law? Well, go back to my initial point. My initial point is that the courts were thrust front and centre into what lawyers would have argued was an important legal battle, but to outsiders it looked like they were occupying a very important political space, and to those who wanted to cause trouble, as the writers of the Daily Mail, they would say judges are blocking Brexit. And you see exactly the same in the case of Poland. I've asked my Polish colleague who speaks, who's actually British but speaks excellent Polish, to give me a list of a large number of the front pages of various Polish newspapers. And what is striking about, if you look at the response of the Polish press, certainly the Polish right-wing press, to the decisions of the Court of Justice, you see exactly the same type of rhetoric. The images are slightly less exciting because they are pictures of basically the Polish Prime Minister and the Polish Minister of Justice being rude about the Court of Justice. But the language is really strong. For example, the European community is attacking Poland again with the help of the Court of Justice. It's all about the jurisprudence of the Polish Constitutional Tribunal. Another case, they say, Court of Justice against Poland and Hungary, Berlin very happy. Another one, the rule of law doesn't apply to Germany. And then there's a lot on corruption in the European Parliament, which, as they suggest, shows the hypocrisy of the EU. Why am I telling you all of this? What I'm saying is that the risk of the court being at front and centre of the rule and law debate plays into a narrative of the elites trampling over the will of the people, whether the will of the people be British people, be Polish people, be Hungarian people. And what we see here is that there is a real risk that the courts lose the respect of the people in the countries affected. The Court of Justice, and in the UK, the Supreme Court, and there is also similarly a risk with the European Court of Human Rights. And that's my concern about seeing the courts as the warriors of the rule of law. So then the question is, what can be done? And this does point to the fact that ultimately the rule of law issue needs to be resolved through political debate. We know that the Article 7 rule of law mechanism was designed as a nuclear weapon, and it has, for that reason, never been operated. Critics, frustrated at the futility of the Article 7 mechanism, have urged the Commission to be more radical and to use other tools at its disposal. Where I would depart from the views of those critics is to say that I think the Commission is being cautious because it's highly sensitive to the issues I've just mentioned about thrusting the Court of Justice front and centre into this highly sensitive, highly vexed, highly contested political domain. And so I think what is striking and what the Commission is doing is looking at a range of tools, the pre-Article 7 mechanism, the cooperation and verification mechanism for Romania and Bulgaria, the rule of law reporting cycle. Yes, they are not as exciting as having a big win before the Court of Justice, but it does protect the Court of Justice and its reputation longer term. The most interesting development, I think, is, of course, in respect to the conditionality mechanism and the fact that it has been deployed now against Hungary. And what we know is that the Hungarian parliament is now very worried, or the Hungarian government is very worried about the sheer losses that Hungary is currently going to be facing, particularly at a time when inflation in Hungary is somewhere between 25 and 30%. And we have seen at the start of this month the Hungarian parliament now at least debating the issue about what to do about the rule of law issues. Now, I'm not so naive as to think that what will happen will be a magical transformation. But what we are seeing is that money talks. And sadly, I think money talks more powerfully in this context than necessarily lots of cases going to the Court of Justice. Thank you very much indeed.
Muchas gracias, Catherine. La Universidad Carlos III.
Thank you very much, Catherine. Universidad Carlos III has acknowledged you with some of our highest honors, and we're very happy to have you among our staff. Sadly, as a guest, because you're a professor at Trinity, which is no small feat, but we do what we can so that you can love this country and that you can contribute to the academic debate. And now, well, I give the floor once again, thanking him for being here, Alessandro Nucara.
Muchas gracias, Carlos.
Thank you very much, Carlos. I'll be giving my talk in English, even though I speak Spanish.
What we heard in the first panel, I'd like to start to say that I'm a lawyer by background. I practiced law for more than 15 years before joining the Commission, competition law in particular. And I criticized the Court of Justice many, many times. And I still do so as a professor in Lille, where I still teach competition law subjects. However, criticizing judgments should not be confused with putting in question the integrity of the institution, of the court. I think we cannot but recognize that the Court of Justice is a key player. It's always been a key player, and I think it was recalled right now in the development of all sectors of EU law, including the rule of law, and most recently, indeed. So while I agree with what Dimitri was saying before, that we must find a way to address the challenges on the ground in relation to rule of law, I cannot agree with his criticism to the Court of Justice as such, to its members. I know personally, because he was my professor in Leuven, Koen Lennarts, and he is one of the apotheosis of integrity. So that cannot be questioned, I think. I don't know if the Commission and the EU institutions are losing by winning, as it was said also before. I know that we in the Commission and in other institutions, we put all our efforts to win this battle. And the Hungarian case that was also recalled just now is one example of that. I think we need also the action for failure to act that was mentioned before. I wanted also to draw on that to clarify a bit a misconception that you see in the media. We get all the time with questions from journalists, etc. The conditionality mechanism is not the magic wand that will get rid of oligarchs in Europe. This is an instrument that, as it was said correctly before, was created because we need an instrument to protect the EU budget, the union budget, from breaches of the rule of law that can affect the implementation of the budget. Okay, so it's not to address any rule of law breach. So this is a misconception that we always hear, unfortunately, also from members of the European Parliament. They think that we should stop paying Orban because he's a criminal. That is not applying the rule of law ourselves. So we need to apply the regulation. I will go a bit into what the conditions are of the conditionality regulation right now. But we should be the first, of course, to abide by the rule of law and apply the regulation in a fair, objective, and impartial manner. This is written in one of the recitals of the regulation, and this is how we do it. So I think Catherine was also referring to a number of instruments that we have in what we call the EU rule of law toolbox. And there are indeed instruments that are, in a way, if you want, preventive or promoting the rule of law, such as the rule of law mechanism, which is different from the conditionality mechanism. The rule of law mechanism is the instrument that leads basically the Commission to draft every year a rule of law report. Since last year, the rule of law report also contained recommendations to member states. So it's nothing binding, so it doesn't have teeth. But it is an important instrument. We also have the EU Justice Scoreboard, the CVM with Bulgaria and Romania that was mentioned as well. And then we have response mechanism. Article 7 was mentioned before, infringements cases that were mentioned before, and we have the conditionality mechanism. Now, the conditionality regulation is in force since January 2021. As I said before, it applies to breaches of the principles of the rule of law that affect or seriously risk affecting the sound financial management of the union budget or the union's financial interests in a sufficiently direct way. And I think it's important to recall that the Court of Justice in the judgments for the cases brought by Poland and Hungary on the validity of the regulation stressed this very much, and rightly so in my opinion, that there must be a link between the breach of the rule of law and the impact on the budget. It cannot be a merely theoretical link. It should be evidence-based. And there again, just to say that this is not the magic wand, in order to have cases, we need to find the evidence that link the breach of the rule of law to the implementation of the budget. So if you don't see 3, 4, 5, 6, 7 cases already since 21, it's because we need to find the evidence. And for Hungary, we were able and we were confident that the evidence was there. I will maybe mention a few things about the Hungarian case as well, now that is in a sense closed with the Council decision of last December. Now, it is also true that the conditionality regulation, precisely because it's meant to address rule of law breaches, it also has embedded in it rule of law, fundamental rule of law principles such as proportionality. I think proportionality is embedded in the regulation. The measures that the Commission proposes to the Council and the Council can adopt should be proportionate measures. And therefore, we cannot, for a rule of law breach that affect the budget for 2 million euros, propose measures that would stop a funding for several billions. There must be a proportionate correlation between the two. So going a bit more now into what the regulation provides. So the rule of law principles that are mentioned in the regulation include the independence of the judiciary that was mentioned many times today, the failing to prevent, correct, or sanction arbitrary or unlawful decisions by public authorities, the failure to ensure absence of conflict of interest, the limitations in the prosecution and investigation services of a member state, etc. These breaches need to have an impact on certain situations. So there is a connection in the regulation that you need to do before you can actually look at whether this has an impact on the budget, between the rule of law breach and situations that are concerned with this rule of law breach. And these situations are the correct functioning of public administrations. For example, if you think of managing authorities awarding contracts under public procurement rules, that is a way that if, for example, there is a problem, a rule of law issue for lack of conflict of interest checks, this affects the functioning, the correct functioning of public administration when they award EU funds to companies. And then, of course, other situations that are mentioned are the judicial review of the actions or omissions by these authorities, the cooperation with OLAF or the European Public Prosecution Office when the member state is a member of the EPPO, the prevention and sanctioning of fraud and corruption, so situations that must be linked to the rule of law breach. Now, one other important condition that is always forgot by the general public and by, unfortunately, also by members of the parliament, is that we can only trigger the conditionality regulation if no other instruments under EU law could protect the budget more effectively. So we also need to do what we call a complementarity analysis. So first we need to look whether, for example, an action by the Commission under cohesion rules could solve the issue, could help protect the budget for a rule of law breach. If the conclusion of that analysis is that the cohesion rules are more effectively or can protect the budget effectively, then we cannot trigger. So if you want, this complementarity analysis tells you that the use of the conditionality regulation is, although it can be used in individual cases, it is probably more appropriate if we have systemic breaches of rule of law principles. For what relates to the measures that can be taken, they are indeed measures with teeth. So money talks, as you were saying, and indeed that's the case. And for Hungary, for example, the decision taken by the Council blocks more than 6 billion of EU funds, more than 6 billion. It's a third, a bit less than a third of the entire cohesion envelope for Hungary. And if we add that up with what is blocked under the Recovery and Resilience Plan, which is more than 5 billion, we make almost a third of the GDP of Hungary. So, and Hungary is, as it was mentioned before, is really in a dire straits situation. So this is a mechanism that puts the member state under a lot of pressure, but it is the fault of the member state. So it's not that we are aiming at putting member states under pressure. So they need to solve the issue, and once the issues are solved, and this is again leads me to mention another element of the regulation. If issues are solved, measures can be lifted and will be lifted on a proposal of the Commission, but still by Council decision. So this is the objective of the measure is not sanctioning. It's not a sanctioning mechanism. It's to protect the budget. So if the member states solve the issue even before we propose measures to the Council, that's the end of it. The issue is solved, and that's the ideal scenario for the Commission. Not to propose measures to the Council. It's not that we want to punish Hungary or Poland or whatever will come next. It is an instrument that gives us leverage to have the member states solve the issues. Now, if you allow me, again, maybe one word on procedure is also that one important element of this instrument is that the procedure is very squeezed. So as I said, I'm a competition lawyer. I am used to cartel cases that can last years and years. I used to work a lot on state aid, and this can also take 2-3 years, depending on the complexity. This procedure established in the conditionality regulation lasts from 5 to 9 months from the moment we have launched it. So we launched the case for Hungary at the end of April last year, and it ended with the decision of the Council mid-December last year. So this is also a feature of the conditionality regulation. Maybe a word on other instruments that are also used, and Hungary, I think it's unfortunately a nice case study, because it's not only conditionality, so not only conditionality regulation that is applied because of certain breaches that we found. They also have the entire cohesion envelope. So the entire cohesion funds are blocked because they are not abiding by what we call a horizontal enabling condition related to the compliance with the Charter of Fundamental Rights. And these, for example, also cover issues like academic freedom that are not covered by the conditionality procedure that we did last year. And it covers also judicial independence in Hungary that is not covered in the conditionality regulation that we ran last year. And then we have the RRF, the Recovery and Resilience Facility, where for Hungary we have 27 super milestones. So it's, let's call them conditions, preconditions for any payment. So the Hungary should get 5 billion euros for the Recovery and Resilience Plan. They will not get one single euro if these 27 milestones are not fulfilled. And these 27 milestones include judicial independence reforms, all the reforms that they need to do to solve the issues under the conditionality regulation, and issues related to control and audit. So maybe to conclude, a word on Hungary. It might be interesting to know what we found. What we found in the Hungarian case is indeed, and this is something which also Dimitri correctly referred to, Hungary is very good in complying with the letter of the law. What happens and what we found is that issues are on the ground. So if you look at procurement rules in Hungary, they publish the tenders, they do perfectly, they do the procedure by the book, but it's always the same company that wins the tender. And we have a concentration of awards into the hands of a few companies that are, interestingly enough, in one way or the other, close to the ruling party, or even the person of the Prime Minister. A concentration of this award which is abnormal. A rate of procurements where we have one single bidder, so no one bids, only one company, which is by far the highest one of the highest in Europe, and very much above the EU average. So we had found issues in the procurement context and issues related to the prosecution service, and the fact that procurement procedures don't work, and if you complain, prosecutors do not investigate. So we have discussed with Hungary how to remedy the situation, and Hungary came with 17 remedial measures that they submitted, and that we addressed as potentially capable of solving the issues. And why did the Council impose measures on a proposal of the Commission? Because we think that the remedial measure is basically what in antitrust terms would be a commitment, a remedy. But what we wanted to see the implementation of these remedial measures in the related legislative text. And we were not happy with the legislative text implementing the remedial measure. So now Hungary is in discussion with the Commission to start the lifting of this measure, but until and unless they address the concerns that are now in the Council implementing decision of last December, there will not be a proposal by the Commission to lift the measure. Maybe just very last word, because I realize I forgot to say the decision, contrary to other instruments, the decision under the conditionality regulation is taken by the Council by qualified majority. And the member state concerned votes, contrary to Article 7 TEU, where the member state concerned has no right to vote whether to trigger or not the Article 7. In the conditionality regulation, because it is a protective mechanism and not a sanctioning mechanism, the member state concerned votes. So Hungary voted in the Council. I will stop here.
Muchísimas gracias, Alessandro.
Thank you very much, Alessandro. I've always known, I think that everyone here knows that the European Commission was one of the greatest secrets of the success of the European milling world. And I think that seeing people like you who come from the private world, who've committed to do everything as seriously as possible, well, it's really comforting. And I knew you via your CV, and well, I'm leaving at peace from here. In any case, I already said earlier that I would use a prerogative here, and I don't like using them because, well, I think that equality of opportunity is crucial, and like Joe Weiler said, and what the Max Planck Institute was doing, and I remember I raised my hand among so many wise men, and I said, have you ever considered what the second part of the fourth article of the European Treaty does within the European Union's treaty? Because that article, which was proposed by the UK, my dear Catherine, well, what an article. It's, I encourage everyone here who haven't read it to think on it, where we mix national security, which is a concept no one knew anything about in the European Union. We talked about public safety, but never about national safety and security. That wasn't the gap it wasn't introduced in the European Union Economic Treaty, and it put national identity and national security was at the same level, and it was quite a mess. It was a mess indeed, because you put that into your treaties, you don't really define what you mean with that, and from there on, well, each member state say, no, this is my constitutional identity. What am I driving at? Well, this thing we're discussing now, and I congratulate everyone here and all of our speakers who have had the kindness of meeting us here, of joining us here. I think it's crucial for European integration because it's superposing the supranational building as if it were imposed to legitimate constitutional order, and I'm going to underscore this, legitimate order in democratic states that asked to join the EU and that were accepted, and from then on, well, this is the meaty part. I'm going to give you 3 data. Olaf Scholz, the Prime Minister of the German Federal Republic, who I don't think anyone can suspect of being, I'm not going to use any qualitative words, but in one of his speeches he said, no, this rule of law can't be solved in the courts. It has to be a political discourse. We have to reach a consensus. But Macron said the same thing, and Heidelberg was where the Polish Prime Minister said the same thing, and it was quite aggressive because he said, you are imposing Polish Democrats, which it was very difficult for us, for Poland to be democratic, and Poland is entitled to complain. You're imposing a liberal democracy, and we have our own model. we have our own rule of law, which you accepted when we joined the Union, and you have your own, which you have not defined as of now, because the onus is on the court here, which already did quite a bit with the primacy right, and they said define rule of law, and I can define if people ask me. And insofar as people ask me, what do I mean by this? And it's that this second part of the fourth article of the European Union Treaty requires an interstate conversation between states more than an international aspect. And if member states do not agree on anything, we are going to see a collection of situations, of very uncomfortable situations, because I believe that no one wants to be seen as them not respecting stuff. It happened with the stability agreement, where there were a collection of control mechanisms that haven't really been used, and that they started and they were violated by the people who established them because they were going to respect them more, and then they didn't abide by them, and then nobody abided by them. But that was a useless mechanism, because at the end of the day, the people who punished the state members who didn't comply were the markets, not the states. When decisions were made in 2010 and 2011, which were completely extraordinary, to create these mechanisms, which were intergovernmental, to save Greece and Ireland mostly, which were the ones that were more in debt, we didn't act supranationally. Markets acted, and intergovernmentally we defended them. But what do I mean with this? Well, someone, and I think that the people who are here, we don't have power to do anything, but we should really sit down and say, if we don't want to see a complete constitutional collapse, and I'm going to give some figures, at a state member level, we had to do something, because the Wilfred Martens Foundation last year published research. You can't say that they are anti-European, and they proved that several European states, the sociological notion, the one that's part of people's minds, of the people who at least were part of that survey, didn't match with the rule of law we were bolstering at a supranational level. So the question I want to ask is, I want to ask everyone here, will the solution be political, like Godek suggested, and like Catherine mentioned, both of her conclusions? We can't ask any more of the court. We can't throw the people against the court. Let's remember what happened a few days ago in the States. A Spanish newspaper published a very in-depth analysis of the Supreme Court's legitimacy crisis, and we're talking about the U.S. Supreme Court. What's the solution so that without ceding any ground where we are not supposed to cede any ground, we don't overcorrect? Because at the end of the day, we're talking about democracy, national identity, constitutional traditions, different ways of understanding democracy. That's my very complex question.
Do we say more, or
No, if you wish to say something.
No, I would just, the final thing I would like to say is that there is a very well-known British economic or political historian called Peter Hennessy, who used to talk about the good chaps theory of government. And good chaps, if you don't understand the terminology, chaps is a sort of public school, we're all friends together, and we all know what the rules of the game actually are. And he has long described the British Constitution as underpinned by the good chaps theory of government, that people know what the rules are, and even though there's not a written constitution, there are constitutional guardrails, and because everyone knows what the rules are, therefore they don't step outside those guardrails. And I think, although he was talking about the British Constitution, I actually think the same applies very much to the European Union. When it was set up, particularly with the original 6 member states, essentially they were all good chaps, and indeed they were largely chaps and not chapesses. They were largely chaps, and they all understood what the objectives of the EU were. Now, whether they anticipated the EU would be quite where it is today is another matter, but it was clear that they were all committed to the process. And all of that works very well until you have someone who is not a good chap. And the reality is that the growing rise of illiberal democracies, and dare I say it, authoritarian governments, both in the EU and on the edge of the EU, requires us to rethink. And the problem is the mechanisms that we have in our domestic constitutions and also in the EU treaties have not really been able to manage these very difficult situations, which is why what we see are the various institutions in the EU running to catch up, the Court of Justice having to do a huge amount of the heavy lifting, and as Alejandro has just explained too, that the institutions are having to quickly develop new mechanisms to try to contain the difficulties that are arising when faced by these leaders who are extraordinarily successful in manipulating populist sentiment and particular social media, none of which, of course, was around in the 1950s, 60s and 70s. And this puts us in a very precarious situation. I think it puts us all in a precarious situation. And it requires us to think, what can we do as lawyers to respond? But the knee-jerk reaction, the courts have got to sort it out, is, I think, one that comes with risks for the reason that I explain, that populists are very, very effective in running the argument that courts are not legitimate.
Thank you, Catherine.
Maybe a couple of things. It is true that when candidate countries want to join the club, there is a whole process that looks into many things, including the situation, the rule of law situation, and the respect of the rule of law in those countries. So what maybe I can say is that certainly at this moment in time, with the current candidate countries, rule of law is high on the agenda of the accession negotiations. I was not there. I don't know what was, the place of rule of law in the pre-2004 accession negotiations. But it is something that the Commission, when now it negotiates the accession of these countries, certainly it's something that we look. If you look at the organigram of the Directorate General leading the negotiations with candidate countries, you will see that there are entire units dealing with rule of law for the negotiations. So hopefully for the future, those who will come in will have some strong structures to avoid that they present the same issues as we are seeing in former candidate countries, now members of the Union. Now, to go back to your question, whether where do we draw the limit between national identity and the protection of the national constitutions and respecting the supranational concept of rule of law, I think the limit is abiding by the law. So if you cannot think that because you have become a member of the Union, you can start a disciplinary proceeding against a judge who puts a request for a preliminary ruling to the Court of Justice. Because that means that you are not abiding by the treaty. You are creating obstacles to implement the law of the club where you just entered. So there is a limit that I would say, and for example, if I look at the conditionality regulation, the limit is that you should implement the budget complying with the sound financial management principles. If you don't, and you don't because there are rule of law breaches, then that's the limit. You cannot say, my constitution allows me to avoid the conflict of interest check. I'm sorry, but that is not the law of the club where you are a member. So the limit is respect for the law and for the rule of law principles that are, in my view, enshrined in the treaty, and that's the treaty that they have agreed to respect. So that's voilà.
Bueno, muchísimas gracias. Es verdad que
Yes, thank you very much. It is true that with this we focus on one of the elements of the rule of law because there are many definitions. But there is a consensus that the most important aspect of the rule of law is independence of the judiciary. And there you have the famous book of Lee Harvard, Democracy and Distrust, that we were asked to study when we took our first steps as lawyers. If you don't know this book, make sure you read it, we were told. But it's not only that, because at the end, the Luxembourg Court of Justice, they have been handed over the ball, so to say, so that they can deal with it. But there are other things that sociologically speaking are much more complex and that cannot be resolved with rulings or sanctions, because liberal democracy, which is the democracy we're living in, a country such as Spain, it is undergoing constant evolution. And I humbly believe that it is necessary to reach an agreement between the member states to establish parameters that go beyond the legal case, because I think that is sufficiently well covered in supranational terms, but there are others. In that regard, is Spain more democratic because we live in a state where social or civil rights are being driven forward to levels never seen in other countries? Are we more democratic than we are? Do we respect the rule of law more than they do? I would be very careful with this, and sorry for abusing the floor, because I'm not one of the speakers, but the tragedy of Europe has been Eurocentrism. So we can go from a reality which is obvious today, which is that Eurocentrism no longer rules the world. We know who rules the world at present, at least who the two main powers are that are leading the 21st century. So I wouldn't like to fall into Eurocentric Europeism, because Europe is a community of nations where there are men, women, people who understand their day-to-day, their future in an X manner. And I always think about the U.S., a state that has been federated for more than 200 years, and some there is a death sentence and others not. In some, abortion is legal, in other states it's not. But they're together. Is the rule of law in the U.S., is it more rule of law in Texas than in New York? Well, I think we're hiding the real debate. Where are we heading to? We're trying to impose with the strength of supranationality that we're running the risk of abusing. Because we're talking about people, we're talking about consciousness, we're talking about people who vote. And for the time being that I know of, there is no single voting subscription in, or it's not the same people voting for the same thing. We vote differently in different countries. So we are in a place whose boundaries are still to be explored, and where I think politics should say something and start so as to stop harassing judges. And I am a true Europeist, and much.